all rise, people. This is a judgment in the matter of the Duke of Sussex and the Secretary of State for the Home Department.
So, this afternoon, we're going to hand down our judgments in the case of the Duke of Sussex against the Secretary of State for the Home Department. I'm going to read out a summary of my judgment, which has been prepared so as to assist the public and the press to understand what exactly the court has decided. It should, however, be understood by all that the full judgments themselves are the only authoritative version of what has been decided. We will have some hard copies of both the press summary and the full judgments here to let you have after the hearing. But the judgment will be uploaded as usual this afternoon to the case law section of the National Archives website, so it will be accessible to everyone. Introduction. In this case, Prince Harry, the Duke of Sussex, seeks a declaration that the protective security arrangements provided for him on his visits to the United Kingdom are inadequate and unlawful. The defendant to the claim is the Secretary of State for the Home Department, whom I'm going to call the SSHD, because she is accountable to Parliament for the Executive Committee for the Protection of Royalty and Public Figures, known as RAVEC, which provides protection for royalty and certain other very important people. On the 28th of February 2020, Sir Richard Mottram, who was then the chair of RAVEC, wrote a decision letter explaining that protection would be withdrawn from the Duke and Duchess of Sussex from the 31st of March 2020. In early 2020, the Duke and Duchess of Sussex moved out of the United Kingdom to live first in Canada and then later in California. The main issue raised by this appeal is whether Sir Peter Lane, who was the judge, was right to dismiss the Duke of Sussex's claim. The judge decided that RAVEC, in taking its decision to withdraw the Duke's security, had good reason not to follow its 2017 policy. That policy provided that RAVEC would evaluate a risk analysis conducted by its risk management board in order to determine which individuals should receive protection. RAVEC had not commissioned any risk analysis from the risk management board in respect of the Duke of Sussex before taking that decision. The judge also decided that the Duke of Sussex was not in an analogous position to certain other VIPs for whom protection is provided by RAVEC. Part of the two-day hearing before the Court of Appeal, which is composed of me, the Master of the Rolls, and Lord Justice Bean and Lord Justice Edis, was conducted in private. Because of the confidentiality of the security arrangements provided for members of the royal family and for other individuals. But the judgments are public, but they have a short confidential annex which will not be made public in case it puts any of the persons protected by RAVEC at risk. Did something go wrong with the process. Ms. Shahid Fatima, King's Counsel, leading counsel for the Duke of Sussex, submitted that this case had an important human dimension. She submitted that the Duke of Sussex's life was at stake because of the decision-making in this case. She said that the bespoke process adopted by Ravek had singled the Duke out for especially inferior treatment as compared to all others protected by Ravek. In effect, it had been predetermined in the decision letter that on future visits to the UK, the Duke of Sussex would be provided with a lower level of security than had been provided for him throughout his adult life. This demonstrated, submitted Ms. Fatima, that something had gone wrong with the process. She submitted that the claimant was still subject to the same risks as he was before he stepped back from royal duties, and that the impact of an attack upon him was obviously still just as significant as it has always been. His military service, she said, placed him at particular risk. Although it was not suggested that no security provision had been made, the Duke of Sussex strongly criticised the adequacy of what Ravek had determined was appropriate. I said in my judgment that these were powerful and moving arguments, and I said that it was plain that the Duke of Sussex felt badly treated by the system. But I concluded, having studied the detail of the extensive documentation, I could not say that the Duke's sense of grievance translated into a legal argument for the challenge to Ravek's decision. The legal question, indeed the only question for the court, was whether Sir Richard had failed to follow Ravek's policy without a good reason. From the Duke of Sussex's point of view, I said that something may indeed have gone wrong, in that an unintended consequence of his decision to step back from royal duties and spend the majority of his time abroad has been that he's been provided with a more bespoke and generally lesser level of protection than what he was provided with in the UK before. But that did not of itself give rise to a legal complaint. Did Sir Richard fail to follow Ravek's policy without a good reason? I said in my judgment that Sir Richard had indeed failed to follow Ravek's policy. But I said that there were four main reasons for holding as a matter of law that Sir Richard had had a good reason for having done so. First, Ravek's policy was inward-facing and unpublished, and it concerned an area of national importance that was peculiarly within the expertise of law enforcement agencies, Ravek, and the royal household. Secondly, in this area of high political sensitivity, the court had considerable respect for Sir Richard and Ravek as decision-makers, because they had unrivaled expertise and experience in the field of royal protection. Thirdly, the decision was explained in contemporaneous documentation to the effect that the Risk Management Board would not undertake further risk analyses for the Duke of Sussex because they were no longer required, given the alternative governance arrangements that were to be established on a case-by-case basis for the future. Sir Richard had, however, obtained 3 threat assessments for the Duke of Sussex during February 2020 before writing the decision letter. Fourthly, Sir Richard and Ravek had given compelling reasons for having reached the conclusion that the appropriate course was to establish bespoke arrangements for when the Duke returned to the United Kingdom on future visits. The Duke was in effect stepping in and out of the cohort of protection provided by Ravek. Outside the UK, he was outside the cohort. But when in the UK, his security would be considered as appropriate depending on the circumstances. It was impossible, I said in my judgment, to say that this reasoning was illogical or inappropriate. Indeed, it seemed sensible. Finally, even if there had been a risk analysis from the Risk Management Board, it would very likely have only confirmed the threat, vulnerability and impact levels which the Duke had faced when earlier risk analyses were undertaken. But it would have had nothing to say on the critical features of the changed situation, which were the need for protective security on future uncertain visits and the government's appetite for risk. The decisions taken in the decision letter and subsequently were taken, I said in my judgment, as an understandable and perhaps predictable reaction to the Duke of Sussex having stepped back from royal duties and having left the UK to live principally overseas. So the conclusion, in my judgment, with which my colleagues, Lord Justices Bean and Edis, agreed, was that the Duke of Sussex's appeal would be dismissed. So that concludes this afternoon's hearing. Thank you.
With the legal commentator Joshua Rosenberg, it was a pretty clear judgment in the end.
Very clear. Sir Geoffrey Voss, the Master of the Rolls, who's a senior civil judge in England and Wales, went out of his way to explain this, as he said, for the benefit of the press who are watching and indeed the wider public watching on Sky News. And he went through all the arguments and he explained why the three judges who were sitting in the Court of Appeal dismissed the Duke of Sussex's appeal, upheld the earlier decision just over a year ago by the High Court Judge Sir Peter Lane. And what we're talking about here is judicial review. It wasn't the job of the Court of Appeal to decide whether these security arrangements were adequate. That's not something that they're capable of doing. What they had to consider was whether this committee called Ravek, which has police people on it, palace representatives, all sorts of other people, they're the people responsible for assessing security for the royal family, for senior politicians and so on. The question is, did this body go about its work properly, or did they behave unreasonably? And as far as the Court of Appeal was concerned, Sir Richard Mottram, who's the chair of it, did go about it reasonably. Certainly, the question that Sir Geoffrey Voss asked himself, did something go wrong, which was what was alleged by Shahid Fatima, counsel for the Duke of Sussex, well, obviously that's what Prince Harry thought. He thought that the security that he was getting was inadequate. And Sir Geoffrey Voss said these were powerful and moving arguments. He felt badly treated. But the question was whether the Ravek committee, Sir Richard Mottram, had failed to follow his policy without good reason. And Sir Geoffrey Voss said he had 4 good reasons for failing to follow the original policy. First of all, this isn't a public policy. It's something that is within the experience of the people on the Ravek committee. Secondly, the court had to respect Ravek's thinking because they're the decision makers, they had the experience. Thirdly, there's all this stuff about a risk management board, but there was indeed a threat assessment that Sir Richard looked at. And finally, there were compelling reasons for establishing what was called a bespoke arrangement, one that was tailored precisely for Prince Harry, given that he didn't need the security when he was out of the the United Kingdom that he would need when he was in the United Kingdom. A risk analysis would have made no difference. The decisions taken by Ravek were correct. They were an understandable and predictable reaction to Prince Harry stepping back from royal duties, living abroad. The other two judges, Lord Justice Bean and Lord Justice Edis, agreed with the Master of the Rolls, and the appeal is dismissed.
Yeah, it's an important point you make, isn't it? This isn't a rerun of the initial decision. It is actually something altogether quite different. Does this draw a line under it, or is there other things that Prince Harry could pursue?
Well, he will obviously try to consider the question of an appeal to the Supreme Court. Now, for that you need permission. There wasn't an application for permission just now from the Court of Appeal. There might be one in writing. If permission is refused, then Prince Harry's lawyers could go and ask the Supreme Court for permission. But what the Supreme Court will look at is whether this is a case of general public interest, general public importance. It seems to me it's one of very, very specific importance to Prince Harry, and exactly how you assess this particular risk is not something that's going to be of general importance, because there's nobody in this position who's stepped back from the royal family and who is wanting the same sort of security as he had when he was doing royal duties. So I wouldn't hold out much hope for an appeal to the Supreme Court.
Yeah, that makes an awful lot of sense. Thank you so much for explaining all the legalese to us. It's much appreciated. Thank you very much indeed. Well, our royal correspondent Rhiannon Mills joins us now from the Court of Appeal in central London. Rhiannon, this would be a blow to Prince Harry.
Oh, an enormous blow. You have to remember that he deliberately made the choice to fly all the way from America back here to the UK for that two-day Court of Appeal hearing. He wanted for himself to sit there and hear all of the evidence that was read out, not just in public, but in private, because as you were hearing in that judgment there, a lot of what was heard was highly secretive, seen as very important that it was kept secret in terms of what is done for protection when it comes to royal family members and also VIPs that travel here to the UK. But for Prince Harry, this is the most personal issue. It's been one of the most contentious problems, as it were, ever since Harry and Meghan decided to move away from the UK, wanted to step away from royal life. And when his barrister was talking through what his case was during that two-day appeal court hearing, she very clearly said that he believed that his safety, his security and his life were at stake because of that decision to not automatically give him police protection when he comes here to the UK. You have to note that when Prince Harry has recently made those visits to the UK, we haven't seen Meghan. We also haven't seen his children either. And he will say that one of the main reasons for that is because they simply do not feel safe. However, the Home Office have all along said that actually they were still assessing what risks he was under, but it was on a case-by-case basis. Rather than doing this kind of top-line assessment that he permanently needed protection, they were taking it on a case-by-case basis. So whenever he came here to the UK, he had to explain to them why he was coming, the intention of his visit, and then they would decide whether or not he needed their protection. I have to say, for Prince Harry, he was talking to reporters after the appeal court hearing. He very clearly said that he realised that whatever the outcome, it may not change things for him. But as with so many of these court battles that he's taken on, he sees this as a real point of principle. He was hoping that it might change things for other people as well as himself. His team have consistently said, and they said that there has been confusion around this, that he has not been asking for special treatment. What he's been asking for is to be treated like everybody else. However, today we've heard in this judgment that it's been decided that the Home Office were doing as much as they should have done, and his appeal has now been dismissed.
Rhiannon, thank you very much indeed. Rhiannon Mills there reporting from outside the Court of Appeal.